Hello everyone, this is Mansi Garg and I am a student of BCom LL.B Honors at UPES School of Law, Dehradun. In this particular video, we will be discussing about SP Gupta versus Union of India. Before starting the video and discussing about the case, I would like to extend my gratitude to our helpful and supportive teacher who has inspired me for making this video. Thank you Bhavana Rao Mam for your support and help. So, SP Gupta versus Union of India, in this particular case, we will be focusing on two important articles of the Constitution of India. The very first one is Article 124 and the second one is Article 217. SP Gupta versus Union of India AIR 1982 SC 149. The Honorable Justice Y.V. Chandrachud was the then Chief Justice of India when this particular case was filed in the Supreme Court of India, while Justice P.N. Bhagwati was appointed as the Chief Justice of the country in 1985. The bench comprised 7 judges, namely Justice P.N. Bhagwati, Justice A.C. Gupta, Justice S.M. Faisal Ali, Justice V.D. Tulsarpurkar, Justice D.A. Desai, Justice R.S. Pathak, Justice F.S. Venkatramaiah. The majority of the judgment was given by Justice P.N. Bhagwati in this particular case. So before discussing about the facts, issues and judgment, let's see background of the case of S.P. Gupta versus Union of India. S.P. Gupta versus Union of India 1981 is the first case, which is also known as the Judges Transfer Case, established a precedent for the collegium system. Now, what is collegium system? Collegium system is a system through which appointment of judges is done to Supreme Court and High Courts, while the second case in 1993 made the system effective in the country and the third case in 1998 clarified the loopholes in the system. In the fourth case in 2015, the court abolished the National Judicial Appointment Commission that helped the president in the selection of judges for the Supreme Court and High Courts. In SP Gupta versus Union of India 1981, the Supreme Court by a majority judgment held that the term consultation used in Article 124 and 217 was not concurrence, meaning that although the President will consult judiciary, his decision was not bound to be in concurrence with them. The judgment titled The Balance of Power and Appointment of Judges uh, in executive, this situation prevailed for next 12 years. Now, what are the facts of the case? Facts of the case are, first of all, the petitioner challenged the circular letter. There was a particular circular letter addressed by the Law Minister of the Government of India to the Chief Minister of each state except Northeast states, stating that particular letter stated that they should obtain consent from the additional judges working in High Court to be appointed as permanent judge in the High Court of other states. The petitioner contended that the letter was a direct attack on the independence of judiciary and therefore he challenged the constitutional validity of the letter. There were two groups of petitions filed. One dealt with constitutional validity of the circular letter, the other dealt with constitutional validity of orders of transfer of Chief Justice M.M. Ismail and K.B.M. Singh. Issues in this particular case was, there were three main issues in this particular case. First one is whether the petitioner had locus standi the matter despite the fact that their legal rights were not injured by the circular letter. Second issue is who has a final voice in the appointment of judges. And the third issue is whether the independence of judiciary was affected by the circular letter of the law minister. Before discussing the judgment of the Supreme Court, let us see what were the arguments from the side of petitioner and the respondent. So petitioner in this particular case was SP Gupta. So let's see what was his arguments in the court of law. So his first argument was the petitions in their petitions argued that the constitutional validity of the order of the central government, which indirectly forced the judges to give their consent to the appointment, as additional judges, or else their permanency in the profession would be affected. They also argued and sought the disclosure of correspondence and communication that was related to the non appointment of judges and their transfer for a short term. Secondly, another argument was that the President failed in his duty under Article 216 of the Constitution to appoint judges in the court to deal with the pendency of cases effectively, and so a writ of mandamus must be issued against him. It also said that the procedure laid out under Article 124 has not been followed properly. Now let's discuss what were the arguments from the side of respondent. Respondent in this case was Union of India. Their first argument was the petitioner has no right of locus standi on the ground that the petitioner had not suffered due to circular issued by the law minister or due to short-term appointment by the central government. Secondly, only a person who has suffered legal injury can maintain a writ petition and no third party can be permitted. Under Article 74(2) of the Constitution of India, which provides that the advice of the Council of Ministers to the President cannot be cautioned in the court of law. And the fourth argument was Section 123 of the Evidence Act implies that evidence from the unpublished official record on state affairs cannot be applied without the head of concerned department. In this particular case, judgment given by the Supreme Court was the majority decision by 5-2 in this case held that the non-extension of an additional judge, that is, in this case, the non-extension of Judge S.N. Kumar was valid. On the one hand, Justice Bhagwati recommended a collegium in order to recommend the names of candidates to the President for the appointment of judges in the Supreme Court and High Courts, while on the other hand, Justice Pathak and Tulsapukar held that the opinion and advice of the Chief Justice of India must be given importance and supremacy over the advice given by anyone else. While explaining the meaning of word consultation, which was a main point of dispute, it was unanimously held that it means full and effective consultation. The decision of constitutional functionaries must be given after considering full and identical facts. So we have discussed about the facts, issues, judgments, and what the both of the parties contended in front of Supreme Court. Conclusion of the case is in S.V. Gupta versus Union of India 1981, the Supreme Court by a majority judgment held that the term consultation used in Article 124 and 217 was not concurrence, meaning that although the President will consult judiciary, his decision was not bound to be in concurrence with them. The judgment titled The Balance of Power in Appointments of Judges in favor of the executive. This situation prevailed for next 12 years. Thank you and have a nice day. That was all about the case.